Hi, I'm Alvin Pasaoa.
Hello, my name is Kevin Jefferies.
And this is the 635 Podcast. The 635 Podcast is about local politics, economics, and social and cultural issues in the Alvin Community College area. The views expressed on the show are those of the participants and do not reflect the views of Alvin Community College. And we're back. Welcome to the 635 Podcast. I'm Albert Pasaoa, and I'm here with Kevin Jefferies.
Hello.
And we're back from summer. And let me see, I got our dates right, I got our name right. And we are ready to hop into the hot topic of the right to carry weapons here in Texas. So, Kevin, what's going on?
Well, it's more specifically the right to carry handguns. If you are 18, 19, and 20, Texas Tribune had a couple of stories recently about a federal judge, and this isn't the first time this issue has come up, but this is an interesting twist on it, but a federal judge saying that Texas can't ban 18 to 20-year-olds from carrying handguns. That is what penal code in the state of Texas has said. And different interest groups have been after this before. The National Rifle Association actually failed an attempt to have that declared unconstitutional. This was about 5 years ago, I think it was, because it violated equal protection. It discriminated against young folks, and the courts ruled that, well, that might be the case, but in the same sense that you can't drink until you're 21, you get a little bit older. Same rationale. You can't carry handguns in public when you're 21.
Let me just get some background information. Like, where do we stand now with the carrying of handguns here in Texas?
Well, it's if you're over 21, it's pretty much open season.
So if you're over 21 and you don't need a license, or you do need a license?
Well, here let's look at it this way. Because one of the things that I looked at to get a little bit of background here, there's two places where we can find the state law. One is by looking at penal code, which is the list of all the things that are illegal in the state of Texas. Title 10 covers offenses against public health, safety, and morals. Chapter 6 of Title 10 deals with weapons, and so that's where you would find the answer to that. The thing that's specifically, I guess, more specifically answers your question is what makes something unlawful. The unlawful carrying of weapons. And so, if anybody wants to follow, it's section 46.02. And it has a list of what sorts of things you can't do. And this has been updated recently because the Texas legislature has made it easier for people to do it. Unlicensed carry, things like that. You don't really have to get a license anymore to have a concealed handgun. And by the way, you can't openly carry a handgun. You can openly carry like a, rifle, things like that, without a license. Mm-hmm. That's what this deals with. Anyway, so a person commits an offense if the person intentionally, knowingly, or recklessly carries on or about his person. What does it mean to carry something about your person? I don't know. Like on or about.
A bag, backpack?
Maybe a bag or a backpack, or somehow it's floating nearby. Anyway, what makes it illegal at the time of the offense is younger than 21 years of age. That's the issue right here. Has been convicted of an offense under other sections right here. So if you've convicted, you're a felon. And a variety of other things here. I mean, the point is that it's relatively open, but the only question is how old you have to be. So this is the latest in a series of cases, and to try to extend this to kids that are 18, 19, or 20. The interest group that brought this forward is something called the Firearms Policy Coalition. I mentioned the National Rifle Association a while ago wanted to get this changed with the idea that it was unequal treatment before the law. It was a 14th Amendment violation, and the courts agreed that the states can do this.
Okay, so first, more historical background. This shows my ignorance of Texas. How long has Texans over the age of 21? By the way, is that 21 and over, or strictly over the age of 21, like 22 and on?
I guess 21 until you're dead, or commit a crime.
And how long has that been going on?
I think since pretty much day one. I mean, it's a good question because, part of the way to get into this is to understand the different ways that, let's say, the Texas Constitution deals with guns versus the national Constitution. Mm-hmm. You've got a Second Amendment, obviously, which is relatively simple, and it's got some language that's has been, let's say, reconsidered by the Supreme Court in a case about 15 years ago called District of Columbia versus Heller. Second Amendment on the national level says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Prior to the Heller case, the well-regulated militia was taken to mean that, all right, so this is a conditional right just in case you get called up by militia to, protect the, whatever, from marauders. Texas has a little bit different, a little bit more comprehensive, and it has some issues that were kind of read into the Heller case by the Supreme Court. So this is what it says in Section 23 of the Texas Bill of Rights. Every citizen shall have the right to keep and bear arms in the lawful defense of himself or the state. Now you're mentioning defense, and not just of the state.
Himself.
Yourself, yeah, and this is what was sort of read into the Heller case. But the legislature shall have the power by in law to regulate the wearing of arms with the view to prevent crime. Now, let me mention this, because, again, we've been going through a period over the last 20 years where there's been a fundamental expansion of the right of people to carry arms. This language has not changed since 1876, but there was an effort last time the legislature met, and I imagine it's going to continue. It failed last time. I don't know how far it went. I wish I could have that information for you, but I failed. But to get rid of that last part, the part that says, but the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime. In other words, get rid of that. If you want to wear arms, if you want to bear arms, you can do that, and the state can't stop you from doing that. With the idea that, again, this is to prevent crime. Anyway, in other words, this has been the morphing of this law, and this has been made applicable to the states. This expansion, which of course didn't need to really didn't impact Texas. It impacted your states like California and New York, which had more rigid restrictions on firearms. But this was made applicable to the city of Chicago in a case called McDonald versus Chicago. Both of these were interesting cases, where the argument was that individuals felt like they were insecure in their homes. Because D.C., which again is under the scope of the national government, it's a national city. It's not within any state, so it's subject to the United States Constitution, the national Second Amendment, and that was applied to a similar situation in the city of Chicago. So this expansion of rights applied through the 14th Amendment to the city of Chicago. But again, it doesn't imply Texas because there was nothing to change. We're already... not just lenient, but increasingly lenient as well, too.
Okay. And so in this Chicago case, well, first of all, about what year was this?
This is about 10 years ago. Let me open this up real quick and look at it. 2010, 12 years ago.
And then this ruling, this was the Supreme Court ruling?
Yes. Both of those were Supreme
Court
cases.
And it struck down restrictions on being able to own or carry
firearms? No. It was a restriction on the city of Chicago. Let's see if I can get to just a very simple definition. The holding from the court was the right to keep and bear arms for self-defense. And again, notice that the Supreme Court is interpreting a little bit more broadly the language in the Second Amendment, holding off to the side the whole militia stuff. For self-defense in one home is protected under the Second Amendment as an incorporated against the states through the Due Process Clause of the 14th Amendment, saying that, any kind of limitation on the ability of individuals to own guns in their own homes. Now, again, that's an important point right here. That's a different thing. That's much more restricted. I mean, I don't think that there has been a case, maybe, again, these folks are probably, these are proponents of not just expanding gun rights in a particular state, but across the United States. It could very well be that they want to go back to, taking the city of Chicago to court and saying you can't put a restriction on individuals to carry guns outside the homes. That's what happened actually recently in a case involving the state of New York, where there was a limitation on the ability. Was it the state of New York or the city of New York? I think it was a state law as it was applied in the city of New York, but I might be wrong with that. Where people could not carry without a license guns, like say from point A to point B, and I guess some individuals are simply trying to take it to a gun range, and they said, okay, we don't want to have a license in order to do this, and the city of New York could say whether or not you had a reason to do so, and they denied these individuals the ability to have that particular license. So that was challenged. That went up to the Supreme Court, and the Supreme Court said the state can't put a limitation on that. So again, you see evidence of this expansion, this further expansion. And I think this is just another way that you can see it. You know, so here you've got individuals taking this piece of legislation. And again, I just kind of read that to you, right? 4602. And it's simple. It's a person commits an offense if the person carrying weapons is younger than 21 years of age. And as I mentioned, a first attempt, because this is a different way. This is an interpretation of the Second Amendment. The other one was an interpretation of the Equal Protection Clause of the 14th Amendment, saying that that person is being unconstitutionally treated unequally on the basis of age. That didn't go anywhere. The Supreme Court, there was an appeal from the state of Texas that went up. Texas was defending it, actually, the age limit. It was not accepted by the Supreme Court. You need 4 people on the Supreme Court in order to hear an appeal, and it didn't reach that threshold. Maybe the current Supreme Court would hear that, but this is an interesting example of strategy. You have another interest group making a different argument, effectively saying that if I recall correctly, the Second Amendment's self-defense, the interpretation that applies to self-defense is an unconstitutional violation of the ability of 18, 19, and 20-year-olds to defend themselves. So it's based simply on the Second Amendment's text.
So what's the Texas court case that?
This is the case. See, it's the federal courts in Texas that are overturning the Texas law.
Okay, so the Texas law creating the age, saying if you're under 21, you cannot carry a gun, is
unconstitutional, according to the federal government.
Now,
according to the federal, to be more specific, a federal district court judge.
Federal. Okay, wait. So let me just try to get this straight. Texas banned people under the age of 21 from carrying guns. Now, how long has that been?
I think since day one.
All right, so for a very long time, people under 21 could not carry guns, and then a federal judge
responding to a case brought to it by something called the Firearms Policy Coalition. That's how these cases work. And remember, again, notice we're talking about, there's this concept we cover in the government classes called judicial federalism. And federalism in general, you got state powers and you got national powers. And you have all these institutions on both of those different levels, and they coincide, but they're different sorts of, limits to one and the other and whatnot. Anyway, state of Texas has its own laws that are enforced at the state level. National government has its own laws that are enforced at the national level, but you've also got a United States Bill of Rights that applies to not just protects you from the national government, but protects you from the actions of the state government. A state cannot violate a right guaranteed in the United States Bill of Rights, or the United States Constitution. And that's effectively what the Firearms Policy Coalition effectively argued to a federal judge in Texas about Texas law.
I'm looking at the article from Texas Tribune. Federal judge says Texas can't ban 18 to 20-year-olds from carrying handguns, and this is August 25th of this year, so very recently. Now that's kind of interesting because this apparently, from what I understand, it applies to Texas as well as probably other states that allow adults to carry firearms, but that are attempting to prevent 18 to 20-year-olds from carrying handguns.
Well,
so
we
that's
don't
really
know that yet. This is how the federal courts work. Now, again, it's a gray area, and I'm not the world's foremost expert on this sort of thing, and I'm certainly not a lawyer. But this is a district court judge. I believe this is I think this was filed in Austin, and I believe then this is the Western district, which starts in Austin, goes off to El Paso, basically. And you have different sorts of courts within it. Now, this decision would apply to that district mostly, but I guess since it's Texas, it would apply statewide. But again, normally, your jurisdiction exists within that particular district. In this case, it would extend to the state of Texas as well, too. But no other state, unless it goes up the next level, the Court of Appeals, which it would include also Mississippi, and Louisiana, and then if whatever, it could potentially be appealed to the United States Supreme Court. This could be a U.S. Supreme Court case before we know it. And if the U.S. Supreme Court rules on this, it can nationalize it. So right now, this wouldn't nationalize it. This just would be Texas specific.
But the crux of this, let's see, reading from the article, Texas law bars most 18 to 20-year-olds in the state from obtaining a license to carry a handgun or firearm. So if this were to go national, I don't think it definitely, I'm pretty sure it doesn't mean that California would have to let 18 and 20-year-olds carry guns.
It might.
I mean, isn't this argument mostly about age discrimination? So basically, the fact that Texas lets 21 and older carry guns means they can't not let 18 and 20-year-olds carry guns as well. But Texas could restrict all adults from carrying guns, and that would be okay. Is that your reading?
No, because all right. What you said before. Again, this is a Second Amendment case. This is an equal protection case. And again, in 2014, if you want to open, I got a link to something called National Rifle Association of America versus McGraw. And Craw. I'm sorry. McGraw is the crime dog, or no, it's McGruff. I'm sorry. This was the issue there. And it was something, as I mentioned, that the Supreme Court said we're not going to rule on this, meaning the lower decision, which said that this was not a violation of equal protection, age discrimination for young people, held. So the issue, whether the Second Amendment right to bear arms for self-defense in case of confrontation includes the right to bear arms in public. That was one question presented to the court. Two, whether that right to bear arms extends to responsible, law-abiding 18 to 20-year-old adults, and three, whether Texas is banned on responsible, law-abiding 18 to 20-year-olds bearing handguns in public for self-defense violates the Second Amendment and the Equal Protection Clause. So it was both of those things, but it was mostly the equal protection issue, as I recall, that dealt with this particular issue. And the thing was that, well, yeah, it does discriminate, but there's a reason. You can get away with treating different groups of individuals unequally, depending upon the question presented. Education is one thing, speech is another thing, carrying weapons openly is a different sort of thing. And there could be a good reason why somebody might, or drinking, being treated equally in terms of that. There could be a good reason. In this case, the Supreme Court. I mean, again, it didn't say anything, but the inference is that this is one of the legitimate uses of governmental power to enforce public safety, and this was a reasonable way. A legitimate way to achieve that particular sort of objective. Now, again, this is like a second time. It's almost like they're backing up a little bit, like, okay, this first argument didn't work. This is my hunch anyway. And the Firearms Policy Coalition, I'm looking at their website right now. I'm not hugely familiar with them, but I know that they have been involved in a bunch of other cases, kind of setting up, other ways that you can expand rights to guns, for everyone. And so, again, it seems like they've been working on this argument, fully a Second Amendment argument. And this is also from that story that you were looking at. Based on the Second Amendment's text as informed by founding era history and tradition, the court concludes that the Second Amendment protects against this prohibition. And this is the judge in that district court. Again, the trial court. This is where the whole thing begins within the judiciary. The order will not go into immediate effect. Pittman stayed the ruling for 30 days pending appeal, and we might be towards the end of that 30 days. The order will not, blah, 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 blah. The decision, again, pending appeal. Again, this has almost certainly been appealed to the next level up, which is the Fifth Circuit Court of Appeals. Who knows when they would hear this? I would assume they would accept it. And then from that, who knows, if it becomes a Supreme Court case, as I mentioned. The Firearms Policy Coalition filed the lawsuit in November 2021. It came months after a legislative session in which lawmakers passed a law that allows Texans to carry handguns without a license or training, despite previous promises from Republican leaders to address gun safety following the 2019 El Paso and Midland, Odessa mass shootings and blah, blah. It doesn't go into much more than that. Now, the other interesting thing, this other story that I kind of linked to here, it seems like the governor, and keep in mind that, we're 2 months away from the general election. And this is the period of time during midterm elections when all members of the plural executive in Texas, which means the governor, lieutenant governor, attorney general, comptroller, land commissioner, agriculture commissioner, all those folks, are, in addition to other executive positions, railroad commission and state board of education, are elected. And he's been getting a lot of heat for not raising the age to buy assault rifles, making it more difficult. And he's saying right now that, and in fact, you can buy an assault rifle when you're 18. It's just the carrying the handgun. That's a different sort of thing. Mm-hmm. And he's saying because of this ruling, it would be unconstitutional. Even though you've got individuals, like especially in the Uvalde area and whatnot, there's growing Republican support towards the border. This could interfere with that potentially. And so he's saying, look, I'd really like to be able to pass this sort of thing, but I can't do it because, according to this judge, that sort of thing would be unconstitutional.
So Republicans are under pressure to restrict young adults from.
They're under pressure to deal with, from like the Uvalde area, the border area. And again, those are areas that are traditionally heavily Democrat, but they've been increasingly voting Republican. And some of those places there was one county that went narrowly for Trump in the 2020 election. So, you've got this shift in that particular direction that you would like to continue. And you have more and more individuals saying, okay, do something about this. It's too easy to get these weapons. But this kind of seems to give him an opportunity to say, well, I'd like to do something, but my hands are tied. Some people have been asking him to call a special session to deal primarily with this, and he's reluctant to do so. Because he's kind of in the, he's got those people arguing on one side, and then you've got the traditional folks, part of your party, part of your coalition, that want to continue to expand, make it easier for individuals to get guns. So this seems to be I don't know if it's going to be successful or not. I wouldn't be surprised if it was, but a way to handle the dilemma posed by this issue. I'd like to act on this, but a federal judge, since they said that the 21-year-old age limit on carrying handguns is unconstitutional, my assumption is that raising the age to purchase an assault rifle to 21 would similarly be unconstitutional. Mm-hmm. But again, that's not completely true because it's just a district judge that said that. You have two levels of judges, judiciary above him to work this out.
Okay, so the order will not go into immediate effect. Pittman stayed the ruling for 30 days pending appeal. So if there is, now who's the onus on to address this? Like, it's going to be appealed by, now who would this
presumably
be? Presumably
it would be the state of Texas.
Okay.
Now again, let me see.
That's interesting. So it would be the state of Texas that would have to
appeal it. Let me look at
it.
something real quick. I don't know if I've been able to get a link to the case itself, and that's an omission that I have right now. This case is, I'm sorry. Yeah, I do have one. Firearms Policy Coalition versus Stephen McGraw, director of DPS. Oh, this is interesting. The one link, that previous link said McCraw with a C. This other one says McGraw with a G, so I don't really know who we're talking about here. Huh. Anyway, but if you click on that, here's the order. Firearms Policy Coalition; those are the plaintiffs, and I talk about this in class, and this is an example of civil law, constitutional law. The argument that a sitting piece of legislation violates someone's constitutional rights. So they're bringing this lawsuit against the director of the Texas Public. Department of Public Safety. Mm-hmm. So it says Stephen McGraw. Now it's back to C. I don't know what this guy's name really is.
Interesting.
Stephen McGraw in his official capacity as director of the Texas Department of Public Safety. And so, yes, it would be up to McGraw in his official capacity as the director of the Texas Department of Public Safety. Those are the DPS people, right? Those are the people that, wear the hats and pull you over and have boots and kind of swagger on the highways. They would be responsible for responding to this.
Now, does the Texas Attorney General play a role?
The Texas Attorney General would play a role. Now, here's the thing, though. Texas Attorney General, I hate to kind of sound, like I'm treating things, simply, but and I think this is probably true of McCraw as well too. They tend to be Republicans. I mean, the Attorney General is, and so I would assume that he would be in favor of overturning this. He would be in favor of the Firearms Policy Coalition, but in his, capacity as Attorney General, he would be in a position to assist the Texas Department of Public Safety in fighting back against this. Maybe he's not. Or if he does so, maybe do kind of like a, not the full-throated defense of it, because again, this is an alternative way to change legislation. So it's going to be interesting to follow that.
Yeah, and whether Abbott's going to try to pick this up,
or if somebody else will. Now, there were some interesting Supreme Court cases in the last term that had to do with a similar sort of situation. I think it was in North Carolina, having to do with redistricting. Where like a federal court ruled in favor of like the I think it was the North Carolina House of Representatives. I'm probably getting this wrong, but it was like that was the Democrats in that office were fine with, and they didn't want to go back against it. They didn't want to file suit against it, but Republicans did. But whether or not someone else can come in and challenge this, that became a kind of interesting issue. And so that they had to file suit in order to see whether or not they could do it. And if I recall correctly, the Supreme Court said, yeah, you can. So someone else, potentially then, if some other agency wants to come in and uphold or defend this piece of the penal code in the state of Texas, potentially they could do that. But you can see how complicated this sort of thing gets.
Yeah.
But the simple answer to your question, if I recall it, is yes. The responsibility for defending this, because Stephen McCraw is the defendant, the named defendant, it would be up to Stephen McCraw and whoever's behind him. And the Attorney General's function is to represent the state of Texas. And obviously part of the state of Texas is governing operations is the Texas Department of Public Safety, and so you would certainly play a role there. But it wouldn't be the name. This wouldn't be the person who's driving the truck so much as assisting the driving of the truck.
Okay. Now this is definitely a tricky issue because, if you're pushing to uphold this, I mean, I don't know how the Republican base would respond. I would actually imagine there'd possibly be a lot of Republicans, most of who are over 20, might be totally fine with restricting the ability for 18, 19, 20-year-olds from carrying weapons.
It could be. I'd be interested to see some poll numbers on that. We know from being ACC personnel, the training we went through, yet another training on issues that might occur on campus, and we had our police chief leading this, and he was just talking about problems associated with certain individuals having guns. He's like, well, I'm a gun fan, I love my guns and all that too, but and so maybe that enters into here. But now keep in mind, this is a court thing, so this is in the courts. And it seems to me that part of what the governor's trying to do, and I'm sure electorally it's the right thing to do, or politically, say, look, y'all, my hands are tied. The courts are dealing with this.
That's true.
So I can't deal with other stuff related to it until we figure this out.
Okay. All right. Well, that's something definitely that we want to keep an eye on. See how Attorney General, Governor's Office, and the head McGraw. We're going to figure out that.
How do we call him McGruff?
We're going to have to figure out how they respond to that, because they are running out of time to file an appeal, if they will. And this can affect definitely many Texans, young Texans' ability to carry firearms. And it's going to be also important to people who don't want to see, young people or any people carrying firearms as well.
Yep.
So keep an eye on that. Until next time, Kevin, we are out of here.
All right. Thank you, bud. We'll see you.